We're looking at question 3 from the July 2024 California bar exam. First thing I see is 4 paragraphs of facts leading to 3 calls. And there's a line at the very bottom of the page that says, answer according to California and ABA authorities. So this is PR. The first call, ethical violations by August. A name, an attorney. Second call, ethical violations in August and Rita's arrangement. I don't know who Rita is. Call 3, ethical violations by Len. Len, L name, that's a lawyer. So call 1 and call 3 are about individual attorneys. Call 2 is about some kind of an arrangement between one of the attorneys and somebody else. Well, I know that at least one, probably more, of these violations are going to be in areas where California differs from the ABA. So I have to watch out for that. What we have is that August is an attorney who represents Paul, P name, Paul is the plaintiff, in a lawsuit against Paul's former real estate broker, Danny. August and Paul have a valid written contingency fee agreement. They tell me it's valid and it's written. Do I need to analyze it in detail? Well, probably not, but I don't know yet. I want to see how many other issues there are in these facts. If there are a lot of other issues, I'm not going to spend a page of my answer on what constitutes a valid written contingency fee agreement. I'm just going to accept the fact that that's what it is. Paul alleged in his lawsuit that Danny was negligent in a real estate transaction, resulting in a lost opportunity to buy land which could have been sold for $1 million profit. Could have been sold. Sounds a little speculative. I don't know what to do with that yet, but that's what's running through my mind. With Paul's permission, August sent a written settlement demand for $500,000 to resolve all issues to Danny's lawyer, Len. Okay, plaintiff's attorney, that's call 1, sent a written settlement demand with his client's permission to the defendant's lawyer, Len. Len is call 3. Len did not respond to the demand and did not communicate the demand to Danny. So we now have a fact that suggests an ethical violation by Len. We'll go through the law later. Let's get all the way through the facts first. But I know that under the stress of an exam like this, I am likely to mix up these names. So I'm going to diagram for myself really quickly who represents who on the top of the page. A is the plaintiff's attorney, L is the defendant's attorney, and I don't yet know who Rita is. But that's a cue to myself. A is call 1, L is call 3, and again, I don't know who Rita is yet. One evening, Paul, the plaintiff, saw Danny, the defendant, and asked her about the settlement demand. Is there anything wrong with that? No. One party is communicating with another, but there's no ethical violation here. This is not a lawyer communicating. Danny told Paul that she had no knowledge of the settlement demand. Paul told August about this conversation with Danny. August did nothing with that information. And there is another fact that suggests ethical violations. He did nothing with it. A zealous advocate would have contacted the other attorney to find out whether it was accurate that his settlement demand had not been communicated to the client. And why? the other attorney may not have received the demand. August has a responsibility to keep this litigation moving. You can't just sit on information like that and do nothing. At August's request, Paul contacted Danny. I don't need to read the rest of the sentence to tell you there's a huge violation here. This is different from Paul's original conversation with Danny in the paragraph before. This is the attorney speaking through the client to talk to a represented party, and that's a huge ethical violation. Cannot communicate with a represented party without permission from the represented party's attorney. So Paul contacted Danny, communicated the settlement demand, and explained why $500,000 was a good offer. This raises so many issues. You see why it's different from the communication in the prior paragraph. This attorney is speaking through his client directly to a represented party and explaining why $500,000 was a good offer. That's taking a partisan stance and not explaining that to her. There are all kinds of things going on here. Danny asked Len about the settlement demand. Len told Danny he did not respond to the demand because it was too high for the value of the case. So there's Len's huge ethical problem. Len has no business deciding whether she should take that settlement offer or not. He has an obligation to communicate to her, and this is an area where the ABA differs slightly from California, so you'll need to explain that. We'll go over the law later. With Paul's permission, August told Rita, an attorney in another law firm, finally, here's Rita, about the lawsuit against Danny. Is there a problem with that? This raises the issue of confidentiality, but he has Paul's permission. So this is an exception to the rule to keep inviolate the secrets of the client. Rita said she knew Danny and could work with her. August asked Rita to assume joint responsibility for Paul's lawsuit in return for 50% of August's contingent fee. A lot of issues in those two sentences. When Rita said she knew Danny and could work with her, August should have immediately determined whether there was some kind of a concurrent conflict of interest for Rita assuming a role in the case since she knew Danny. And they're proposing a fee splitting. So this raises all the rules about fee splitting. Rita agreed, and August wrote to Paul explaining the new arrangement. That is not good enough. What do you need to do if you're going to split fees with another attorney? You need written informed consent from the client when you enter into that fee splitting agreement. And he did not do that. He just wrote to Paul explaining what he was doing. That's not what the law requires. Within a matter of days before Paul received August's letter, Rita settled Paul's lawsuit against Danny for $500,000. I'm not quite sure what the best way to handle that wording is. The wording that says that Rita settled Paul's lawsuit against Danny for $500,000. It was with Paul's permission that August had sent that settlement demand. But I don't think that's final until Paul signs it, until he authorizes it. So I don't think I'd make a big deal out of that in my analysis because there are much bigger issues than that. But it is Paul's final call about whether that really is settled or not. There are so many other issues, though, huge ones involving fee splitting. So let's take a look at the law. Back to Proponix, which is our online software platform in which we put our bar outlines they unfold. I'm going to the ABA rules first, and you'll notice that we have a summary of the model rules, and we also have an analytic framework. And I'm going to start with the analytic framework. We suggest that instead of going down the rules, the ABA rules, in checklist fashion and always starting with the first ABA rule and working your way down, instead view the fact pattern and think about what's going on in terms of the attorney's duty to be honest, to show integrity and fairness, to be loyal, to exhibit due care. This is more of an organization like that in other professions as well. You'll see that I'm going to the duty to be truthful in communications. No communication with represented persons unless with written consent of opposing counsel or authorized by law or under court order. So there's a clear violation here by August, when he had his client speak directly to the opposing counsel's client. So August should not have asked his client to speak directly with her at all. He was communicating with an unrepresented party through his client without the other attorney's permission. But look at the second part. When communicating with an unrepresented party on behalf of a client, do not imply impartiality, only advise to seek counsel. So the more subtle thing in those facts is that in explaining why $500,000 was a good settlement offer, they were not being impartial. They were implying impartiality. They should have only advised her to seek counsel. Most candidates with passing scores will have seen the problem in communicating there. But if you want a high score, which I assume you do, you also want to see the more subtle points, like this was implying impartiality, explaining the value of that offer. So then, what about integrity and fairness? What are we thinking about there? There we have the rules on fees. And you know fee splitting is a huge one here. The ABA says fee splitting between lawyers in different firms is allowed only if the client consents and the total fee is not increased because of the fee splitting. They didn't increase the fee, so that's okay. In California, there's an additional requirement. The amount each attorney gets has to be proportional to the amount of work they put in compared to the other attorney. So is 50% reasonable? I don't know what the answer to that is. I don't think the bar would care which way you came down on that as long as you discussed it. She's stepping in after the complaint has been written, after the settlement demand has been written. All she's doing is speaking with the client, which in itself is a violation without the other attorney's consent, and arranging for her to agree to that settlement amount. That doesn't sound like it's an equal share of the work, but just analyze it for the greater. But there's another problem here. In California, in order to do a fee-splitting arrangement, you have to get the client's informed consent in writing at the time you make the arrangement, and August did not do that. What about reporting misconduct? Len didn't communicate the settlement offer, and that's a violation. So what's the obligation under ABA? Shall report a violation that raises substantial questions as to a lawyer's honesty or integrity or fitness. So I think under the ABA, this is a shall report scenario. California is different, and there's been a recent change in the California rules that you need to know about. We'll come to that after the ABA framework. Under loyalty, we have the rules about concurrent conflict of interest, but I want to skip down to due care and look at the scope of representation. Abide by the client's objectives, consult on the means. But you have to abide by the client's decision to settle. Len did not do that. So that's a violation on his part. Under zealous representation, think about the fact that August did nothing when he was told that the defendant had not received the settlement offer. And then, of course, confidentiality. That crops up in virtually every PR fact pattern. And here, it's in knowing it that talking with Rita was okay because he had informed consent from the client. In California, we're really protective of confidentiality, and so you need to hit that one. And then the other one is communication. Len blew it here. He should have kept the client reasonably informed of significant developments, and he didn't do that. He didn't communicate the settlement offer. California has a much more specific rule about that. We'll come to that shortly. It's misconduct to violate a rule or to assist another to do so. So there's misconduct in this fact pattern on the part of probably all three attorneys. But I'm going to go over to the California rules and look at some major distinctions from the ABA model rules. In terms of client-lawyer relationship, duties to client, look at communication. Must promptly convey all significant developments related to the representation, including promptly replying to client requests for information. But let's open up the details in the duty of communication and look at the third one here. Promptly communicate the terms of plea bargains or settlement offers in criminal cases and any written or significant oral offer in a non-criminal case. It was a written offer, and it was a significant offer. So Len violated his duty when he chose not to communicate that. Under fees, fee splitting. Look at the detail here. For any fee splitting among attorneys, you have to have a written disclosure and informed consent from the client at the time of the agreement. It has to include the identity of all parties involved. And there's a further obligation here that the split has to be proportional to the amount of work. And then let's take a look at confidentiality, because California is pretty big on confidentiality, much more restrictive than the ABA. There are no required disclosures. This fact pattern doesn't really push at that one, but it's good to get in your answer that quote, maintain inviolate the confidence and at every peril to himself or herself preserve the secrets of the client. This communication with Rita was okay because he had the client's consent. Under third-party transactions, in California, it's a crime for an attorney to engage in deceit or collusion. I don't think that happened here. Could you raise it as an issue? Yes. I wouldn't have had time to. There was too much else going on. Under integrity, on reporting violations of the rules, in California, we now have, as of August 2023, we have what's called the snitch rule. When an attorney has credible evidence that another lawyer committed a crime or did something dishonest or reckless, then the attorney shall, without undue delay, report it to the state bar or a tribunal. Unlike the ABA, we do not have a duty to report any violation by another attorney. This is the snitch rule, but it's still pretty narrow, isn't it? And I don't see Len's conduct as rising to that level. He failed to tell the client about a settlement offer, but I don't find that to be a crime or something dishonest or reckless. So I would say that even under California's new snitch rule, August does not have a duty to report Len. You may interpret it differently. Let's take a quick look back at those 3 calls. Call 1 is August, ethical violations. Call 2 is about the fee splitting arrangement between August and Rita. And call 3 is about Len. So about August. The key facts I would use for that call are in the end of the second paragraph, that August did nothing with the information he got from his client about the failure to communicate the settlement agreement. The first part of the next paragraph, where Paul contacts Danny at August's request, and so August has violated the rules about communicating with a represented party in multiple ways, as we talked about. And then the first part of the last paragraph, with Paul's permission, August told Rita, an attorney in another law firm, and he formed this relationship with her, and he failed to communicate with the client first before he allowed Rita to go and try to negotiate this settlement agreement. And in doing so, he was apparently encouraging Rita to communicate directly with a represented party again. That's call 1. The bulk of the facts for call 2 are in the last paragraph of the hypothetical. We already talked about the rules about fee splitting pretty thoroughly, the ABA rule and the more restrictive requirements in California. Call 3 about Len. Call 3, Len's violations are all around his failure to communicate the settlement offer, which was not only a failure to communicate, but it was also him violating the scope of his representation. He was not entitled to decide for her whether that was worth looking at. It was her decision to make. I thought this was a tough fact pattern because there were 3 attorneys involved, 3 calls. You had to keep everybody straight. But more than that, it wasn't a straightforward one attorney with a fairly obvious concurrent conflict of interest. This was much more specifically about fee splitting and about the duty to communicate settlement offers, very specific rules. The first essay in this bar exam was a very straightforward corporations essay, fiduciary duties. The second essay would have freaked out a lot of people because the first call hinged on an interpretation of the rule against perpetuities. It was an executory interest, a defeasible fee. This one was tough, not in that the rules were that complex, but that you needed to know them very specifically. But you know that a California professional responsibility essay hypothetical is going to give you areas where California differs from the ABA. Oftentimes, that's in terms of fees, and it involves the duty of confidentiality. Those were both present here. But one final thing, notice this is essay 3. This was the last essay in a 3-hour test block in the morning. If you went over in time on essay 1 or essay 2, then you had less than an hour left to do this PR essay, and that would have cost you dearly. So I always remind people to try to stick to 1 hour, 1 essay on the California bar. That third essay is very often professional responsibility or evidence, and you really can't handle those in less than an hour.